Aman Sinha, I want to bring you in, and that's a fair point that Mr. Hegde is making. You yourself as a lawyer, are a lawyer. You understand, how the time of the court can be wasted, where people wait years or rather some decades to get their cases solved. Aren't we somewhere down the line wasting the time of the court when we are going to court on issues of the Qutub Minar? Because where does the buck stop tomorrow?
Well, Preeti, I do not believe that courts till this point in time have in any proceeding said that anybody's attempt or intent was to waste the time of the court. Now, we are a democratic country. You cannot prohibit or stop people from even approaching courts of law for asserting their legal rights or for securing justice. That is the basic tenet of any constitutional democracy. Now, as far as the Places of Worship Act is concerned, as Sanjay was also mentioning, and as I mentioned earlier, that constitutional validity itself is under challenge. The sheer fact that whether certain provisions are going to be attracted or not, Section 3 and Section 4, namely, in view of the fact that large number of these monuments are ancient monuments, declared ancient monuments, more than 100 years old ancient monuments. Therefore, they would also get the exemption as enunciated under Section 4 of the Places of Worship Act. And that apart, for instance, in the case of Gyan Vapi, Preeti would recall that there is a Gauri Shringar Mandir which is on that very same wall, and the worship suit was for worshipping that particular deity only. And which is the original religious character of the place? Obviously, everybody knows originally it was a temple. But even on 15th August 1947, whether originally it was Gauri Shringar Mandir wall or what wall, that obviously needs to be ascertained. Supreme Court itself has said that these are matters which require to be ascertained. There is no bar under Places of Worship Act to ascertain the religious character of a particular place. So therefore, I do not feel that there is any wastage of time at all, as it has been alleged. In fact, if that was the case, courts would have said so very categorically.
But, Mr. Sinha, the courts did say so very categorically. The Allahabad High Court, on when your party colleague from the BJP, Mr. Rajneesh Singh, who handles the media cell where Ayodhya is concerned, approached the Allahabad High Court on Taj Mahal to open those 20 gates, was told by the Allahabad High Court that stop wasting our time.
I am not going into each and every case. There was a case, it was decided on its own merits. You cannot, paint the entire picture from one brush. Because, and therefore I mentioned to you, Preeti, that each and every case is going to be examined on its own merit. And we cannot paint everything with one brush and just either dismiss everything or say everything is hunky-dory. That cannot be the approach, and therefore I said right at the outset that let us leave this to the wisdom of our courts. And there are several levels of judicial hierarchy, and there is a robust judiciary that we have in India, and I'm sure they will take appropriate, suitable view in all these cases. And I can assure you that, and from my own assessment as a senior advocate, that in all these cases, courts have been taking a very fair and a reasonable view. That is what I can tell you.
All right, Sanjay Hegde, I'll bring you in on this, because Mr. Sinha does have a point, because even if we look at what the Supreme Court order was, the Supreme Court could have, if it wanted, shut the entire case down without even putting it across and handing it over to the district court in Varanasi on the basis of the 1991 Act. It did not do so.
Well, the Supreme Court may not have done it for very many reasons, but the primary reason is simply this, that if the Supreme Court takes a decision either way, there is no appeal from the Supreme Court. So therefore, the Supreme Court often, when it is faced at an interim stage with conflicting stands, says that it will not decide things itself. It will send it to the lowest court of first instance, and from then on let the final decision work its way through the courts. For example, you may remember that the Supreme Court was faced with a special investigation team which said that close the case with regard to 2002. The amicus curiae said no, there is something to be looked at in that case. The Supreme Court then sent it, did not take a decision itself. It sent it back to the magistrate so that the magistrate could rule in the first instance. From there, then it went to the High Court, and from the High Court, now it's again come to the Supreme Court, which is hearing the appeal. That is the primary reason why the Supreme Court did not, in this instant case, which is still at the interim stage, pass any final ruling. But to assume that just because the Supreme Court did not shut it down, that the lower courts are bound to continue it and continue it for eternity and to keep the communal pot boiling, I don't think that is a right takeaway from the Supreme Court's order recently.